in this case, and there are a number of matters that we need to address. I'm going to ask first that we address the motion for CR 11 sanctions that's been filed by Mr. Thomas.
Your Honor, my name is Joseph Thomas, and I'm counsel for the plaintiffs Brian Green and Brian Cortland. And so, first of all, plaintiffs filed a joint motion to strike and for sanctions. And we make an argument in here that there's a lot of irrelevant things being brought before the court that's not properly in front of the court. First of all, plaintiffs argue that this court should strike any public records requests that were not communicated to the requesters within the scope of the two requests at issue in front of this lawsuit. Lewis County talks about that there's hundreds of requests going on, and they say that this impacted Lewis County's ability in order to respond to the public records request, but there's nothing in the evidence that would suggest that. The Public Records Act is best served between communications between agencies and requesters.
The Public Records Act what?
The Public Records Act is best served by communications between agencies and requesters. And that's a quote from Hobbs versus State, which is 335 Pacific 3rd, 1004 at page 1011, and it's footnote 12. And the WAC also agrees with that communications are likely to be a smooth public records process for both. Our communication is usually the key to a smooth public records process for both requesters and agencies. And so we should only be talking about what has been communicated here between these two requests. There's no evidence in the record that any of the other requests impacted it. There's actually, in fact, evidence produced by Lewis County that records were available and should have been produced on July 20th. It's in Ms. Amron's declaration to that effect. And so I'm going to skip through the rest of the motion to strike.
Thank you. And Mr. Thomas, I did have a question for you. You filed a document, I'm looking for it here, entitled Plaintiff's Request for Mandatory Judicial Notice.
Yes.
State v. Hobbs is a well-recognized Court of Appeals case that is binding upon the court. I was confused as to why you felt a need to file this document.
Thank you for that question, Your Honor. Looking at page 8 of Lewis County's response brief, they state, or it appears to state the standard of Hobbs, and it says that a denial may arise from any agency, action, or inaction, but in the absence of a denial, no cause of action exists, and the requester's claim fails. So that only captures part of the holding from Hobbs.
I understand the argument. I'm specifically asking what the purpose of filing a document asking the court to take notice of a decision that the court is bound to take notice of without the filing of any pleading. I'm confused.
We hope it's superfluous then.
Very well.
We weren't sure, we were erring on the side of caution. And so going back to the sanctions, the plaintiffs are arguing that Lewis County misrepresented facts to this court when it said that Lewis County acted diligently with response to the request. Plaintiffs make a couple of arguments in order to substantiate this argument. The first factual example of Lewis County not acting diligently is taken from the sworn testimony of its public records officer, Kim Amron, offered by Lewis County in this case. At Kim Amron's declaration on page 6, paragraph 15, the first sentence says, After this point, I did not diligently send out extension letters to Mr. Cortland and PNW PDR, which I regret. We're not mincing words here to this court. Ms. Amron actually used the words that they did not act diligently. And Lewis County is representing to this court that everything they did was reasonable and diligent, and that's not true, as a matter of fact, even according to their own witnesses. The second reason why it's a misrepresentation to this court, as a matter of fact, is because in the declarations of both Kim Amron at page 4, paragraph 12, and Ms. Casey Mowerman, actually I'll just pull up on Ms. Casey Mowerman, and Ms. Amron at page 4, paragraph 12, states that she had records available to her on July 20th. The information technology employee, Nat Trent, gave her records that she asked for responsive to these requests and produced them to her on July 20th. This lawsuit was filed 50 days later, 5-0. And those records were not produced this lawsuit was served 50 days later. And those records were not produced until 1 week after this lawsuit was served. And that can be even evidenced in Ms. Mowerman's declaration. On page 3, paragraph 14, when she states, I certainly would have reached the request P001233 and P001339 during this review. I was on my way there, but I had not reached it yet in the sequence when I learned of the lawsuit based on these requests. Because of the lawsuit, the Lewis County Risk Manager and I pulled those records to the top of the stack to review them out of sequence. In paragraph 16, she indicates that they were Ms. Amron's records that she pulled out of the stack and was going to produce to plaintiffs 1 week after the lawsuit. So Lewis County did not act diligently, even by their own admission of their public records officer. And that's the basis of the crux of their defense. They claim that they acted reasonably and diligently, and as a matter of fact, they did not.
So, Mr. Thomas, I understand the arguments regarding going to the merits of whether or not a Public Records Act violation occurred, but is that your basis for the request for sanctions?
Yes, Your Honor. CR 11 sanction says that arguments need to be well-grounded in law or fact. Here, plaintiffs are arguing that these arguments are not well-grounded in fact. When Lewis County is asserting to this court that it diligently searched for records and produced records, and when its public records officer contradicts that statement itself in the declaration and says that it did not act diligently when sending out responses, plaintiffs will assert to this court that that is not well-grounded in law or fact, and that could be a consideration in CR 11 sanctions.
I'll hear briefly from you, Mr. Heisenberg.
Thank you, Your Honor. Lewis County did not attempt to hide those facts in any way. In fact, they're placed in the declarations that Lewis County submitted. And they're the facts that are not as good for Lewis County, like Ms. Amryan's admission that she had not diligently communicated with the plaintiffs, are also in Lewis County's brief. We made no attempt to hide that from Your Honor. But that doesn't mean that those admissions are an admission of loss on the ultimate legal issue of whether as a whole the response was reasonably thorough and diligent. Saying that one should have communicated better is different than saying that the failure to do so was unjustified or was unreasonable under the light of the rest of the facts. So Lewis County has specific cases, Hobbs, Andrews, and Ruffin, which is spelled R-U-F-I-N, that outline a total circumstances test, and it's trying to give the court all of those circumstances, and some of them are good for Lewis County and some are less good, and arguments can be made about those. And when an argument can be made in good faith under existing law, or about changing existing law in a good faith way, it's not sanctionable. So I ask Your Honor to deny the motion for sanctions and the motion to strike for the same reason, because it's a full facts and circumstances test. Thank you.
You're welcome. Well, I wanted to address these issues, but quite frankly, Mr. Thomas, and you can probably tell from my questions to this point, to me these are arguments as to really whether or not there's been a violation of the Public Records Act regarding these two public records requests. The court sees no basis for sanctions based on this record, and the court also sees no basis to grant your motion to strike, and so both will be denied. I would like to get to the merits of this issue, and specifically because we're running short on time, and if I'm fine not having this matter resolved this morning. If the parties feel they need more time, we could continue the hearing to 1:30 if we need to, but it seems to me, and I'm willing to hear from the parties, of course, but the real issue in this case, to the court's mind, was the fact that Lewis County, and I have the dates here, on what's been described, I know there's a longer number, the 1233-50817, that in that public records request, that Lewis County responded appropriately, but then had their extension of the estimated date for response until June 30th. And then there was an email, I believe, from the Ms. Amrine, I believe, June 23rd to Mr. Green and Mr. Cortland that in general talked about her, how she was working through the large number of requests that she had, but it was uncontroverted that she had not extended, as we discussed just moments ago on the request for sanctions, that she had not extended that deadline, and in fact, the records were not provided until after the filing of this lawsuit, which occurred on September 1st, when it was served on Lewis County. Also, and a similar question is regarding Public Records Request 1339-52617. On that matter, again, Lewis County initially responded appropriately, but then again they had a extension and did not follow that extended time, and again the records were not provided until after the filing of the lawsuit, September 1st. And I believe in the 1339 cause, the deadline had been extended to a date in July, if I'm correct. So specifically, what I'm curious about is why, and I'll give Mr. Thomas an opportunity to state whether that's an accurate statement from your client's perspective, and then I'll hear from Mr. Eisenberg as to why that's not a violation of the Public Records Act.
Your Honor, I believe plaintiffs would agree with that characterization. We do not take issue with the fact that we believe that Lewis County did respond appropriately in its 5-day letter, and it did give extensions properly. The problem is that Lewis County defaulted or did not follow up with those extensions until they produced documents on September 8th, 1 week after the lawsuit was served upon them. Even in request P001339, the record indicates that plaintiffs actually went back and tried to communicate with Lewis County and try to figure out what the reason for the delay is. Lewis County in both instances told them it was because they were short-handed. And that happened back in May. And my clients wrote to Lewis County and said, why is Lewis County short-handed for 2 months? Can you please explain this to us? Lewis County said that they chose not to follow up because they would rather prioritize producing documents than communicating with my clients. And that's fine, but that does not excuse the fact that they didn't send an extension letter or they didn't give them any reasonable indication that more documents would be coming until after the lawsuit was served.
Thank you, Mr. Thomas. Mr. Eisenberg?
To answer your Honor's first question, I think that the facts as you recited them are also what Lewis County believes the facts to be. In other words, initial correct procedure, dates given of June 30th for one request and July 20th for the next. Plaintiffs do send a letter in one of the requests on July 6th asking for an explanation. Lewis County sends them no response. They served Lewis County with the lawsuit on September 1st, and the first responsive documents come on September 8th. It is worth noting that, to complicate those facts just a bit, that Ms. Amrine had partially responded to one of the requests by noting that there were no responsive records for 2 of the items in one of those requests before that date. But in terms of when records were given out, not until September 8th on each of those requests after the date of the lawsuit. So then the question is, why is that not a violation of the Public Records Act? And the answer to that is that it is true that none of the communications in these requests said that we were going to be giving them records at a later date, but also all of the communications that did occur indicated that records would be coming. There was no indication whatsoever that Lewis County intended to deny the requests or that it was going to be claiming an exemption in a blanket way for these requests. Rather, there was communications about how we would provide records and then a cessation of communication. One that Ms. Amrine admits she should have done better. But I do think it's important to note that it's not the case that there was no communication with these requesters at all. There was communication on other requests, which is part of the reason that that is before Your Honor, that there was record provision and communication in many other requests that just wasn't these 2. So even from the plaintiff's perspective, they had not heard from Lewis County that it intended to deny these requests. They heard that Lewis County intended to give them records. They stopped hearing on these requests, but they were getting records and communications on other requests. And so there's not really anything, even just from the plaintiff's perspective, that would suggest to them that Lewis County had wholly abandoned these and had denied their requests. It may be the case that Lewis County was not giving them the stuff in these requests as quickly as they had estimated or the plaintiffs would want. But it wasn't the case that they were told deny. And the reason that's a fact of consequence is that Hobbs is about suits like this. Now, I will admit freely that this case is not as clear as Hobbs, because in Hobbs and in Andrews and in Rufin, the time delay is less. But the point of Hobbs is that when a suit comes when the agency didn't appear to be finished with the request, the question is whether there was final agency action or inaction denying the request. In Hobbs, we were talking about action, and they didn't really address inaction all that much. But they do cite approvingly to Andrews, and Rufin follows Andrews, and that's relevant to the inaction question. I think the question to be answered is, was the inaction from Lewis County in this case the type of inaction that means that Lewis County was, in practical effect, not going to be producing these records, or that they had blown it off to such an extent that it should be treated as a denial of access? If there were no other requests or other facts to be had, perhaps 50 days or 70 days with no action would be such a denial. But in light of the many, many other requests that they were working on in total, but also specifically for these gentlemen, the inaction isn't inexplicable. It's explicable, and it isn't unjustified. It's justified. So Lewis County has never taken the position that it couldn't have done better by sending out a letter in every single request, all 500 of them, to say that they would need more time. But that, as set forth in Andrews and Ruffin, the missing of that deadline is not really the question. The question is whether Lewis County was, as a matter of actual fact, under all of the circumstances, working on the requests in a reasonable fashion, and whether it actually did produce records within a reasonable time and with reasonable thoroughness. So you have quite a bit of discussion from the two public records officers that worked on these requests about what they did and where they went looking for records, and how the very large number of other requests, mostly from Mr. Cortland, some from Mr. Green as well.
Mr. Eisenberg, I want to hear you out, and I feel I also want to hear from Mr. Thomas, and I'm aware that we're past the noon hour, and I need to give court personnel their lunch. So are you both available to be back at 1:30?
Yes, Your Honor.
Yes, sir.
Then it'd been my hope that perhaps we'd be able to get everything done by noon, but I think out of fairness to both of you, even though I think you both can tell at least what my thought process is at this point, I want to give you both the opportunity to fully put forth your positions. And so I think we're going to need to continue the matter to 1:30. So I hope you both have a good lunch, and I'll see you back here at 1:30.
Thank you, sir.
Thank you, Your Honor.
You're welcome. Court will be in recess until 1:30.
All rise.
His argument, and so please continue.
Thank you, Your Honor. So, just to zero in on your question, the question is, if you don't respond to in one of the requests, in the other requests there wasn't a follow-up the way there was in 1339, but if you don't respond and you've missed your deadline, how can you not have violated the PRA? And the answer is that just missing the deadline isn't the analysis. The analysis under Andrews and Ruffin is whether, under all the circumstances, your dealing with the request was reasonable. Was it reasonably thorough and reasonably diligent? And that's because, as Hobbes frames it better, really, than Andrews and Ruffin, in that it says that what the PRA entitles you to is a process. You make a request, the request gets acknowledged, and the process starts of searching and delivering records to you. Sometimes it involves exempting them as well. And that process takes time, and it isn't over till it's over.
But under Lewis County's argument, when does that effectively become a denial? So 30 days, 50 days, 70 days, 100 days?
And I don't think that there is a line that you could draw in terms of days without discussing the rest of the circumstances. And I mean, maybe that sounds crazy, but the reason it's not is that you can't tell whether what's happening is reasonable until you look at the circumstances. So for example, if the public records officer unexpectedly falls terminally ill and then dies, that is a fact that's outside of the request itself. That would certainly be relevant to how long it would take the agency to work on it. Now that might be an extraordinary fact that's outside of the normal course of Public Records Act cases, but it's the same principle that's being applied to a lesser extent when you're talking about more normal circumstances. So Andrews talks about other essential functions of the agency, specifically other records requests. The state patrol in that case had 1,000 other requests. Ruffin makes that analysis even more specific in that it's talking about the specific interaction between the requester and the person working on the request, and really what was taking their time up. In Ruffin, we're talking about the requester has just 2 requests, or 2 other requests, and there's one more big one that the person is working on. And that alone was enough to justify the difference between 20 days and 65 days. So that's 35 days. So then here, we're talking about twice as long, 70 days as opposed to 35 days. But rather than just being a couple of requests, we're talking about 200 other requests. And this is something I wanted to point out in the oral argument because there's no way to do it in the brief. But as a matter of practice, because of the local rules requiring binders, when bench copies are submitted. Your Honor wouldn't have been able to do this with the copy that you received. But the point of Exhibit 2 is really this, that if you flip through it, you can see that the amount of work that Ms. Amrine was doing for these gentlemen's requests was almost all the time. I mean, there's colored boxes on every page almost, except for one section where there's an extended period without that color. And if you look at the dates, you'll see that's all on one day. She just was working on some other big request that day. So the idea that Mr. Green and Mr. Cortland would reasonably conclude that nothing more was to be done on their requests is belied by the fact that lots of things were happening on their requests. And if we were to dig into it, I think you'd find that they weren't getting communications necessarily telling them they'd be getting records on these cases until they got the communication saying, here are the records. Because Ms. Amrine testified that she was working to try to get them the records they had asked for, because that's the purpose of the PRA, is to get them the records. And that she would have had to take a substantial time out from that practice due to the number of requests to instead tell them it'll be later. She wanted to get them records instead. Under the circumstances of this case, that's reasonable. There is a particular, I think I mentioned before we took the break, that the facts in our case are not perhaps as good as in Andrews or Ruffin or Hobbs because the delay was longer. But one fact that this case has that none of those cases have, and in fact, at least in my knowledge, no other PRA case that I've seen in Washington has, is the sheer number of requests from the same requesters. That's an unusual fact. It's simply more reasonable that it would take longer to do the work for the single request when it's bundled with many, many other requests all coming in the same relative time period. Because it's obvious under the design of the PRA that when those requests come in to the same people, from the same people, that of course they're going to have to be working on those too, and Ms. Amrine was. So the reason that it doesn't violate the PRA for there to have been that gap is because the purpose of the PRA is to get records to requesters, and Ms. Amrine was fulfilling that purpose by trying to work on these other requests for the same head. It could have been done better, and Lewis County admits that, but it wasn't a denial of access. You see, there's more than one type of PRA claim. And the claim that the plaintiffs have brought is that Lewis County denied them access to the records. Not that their response was not within a reasonable time. They didn't bring a show cause action. They brought a denial action. And Lewis County, as the witnesses testified in their declarations, had no intention of denying them access to these records. They just weren't able to get them out yet because of all the other records that they had to provide. By the same token, Mr. Thomas has brought a claim about the inadequacy of the search. And his analysis, I think, I don't know if it states it directly, but it's predicated on the idea that you have to do the search for the full scope of the request initially, and that the installment nature of the request, or the fact you're going to be continuing to work on it for a long time, that you violated the PRA if you didn't find all the records up front, even if it's going to take you a long time to provide them. That has sort of the same flaw as the original argument, that the PRA entitles you to a process in which you get state records, but it acknowledges that that process must be balanced in light of the duties of the agency and that it may take time. And so the search, just like the responses, may be done. You search here and you find records and it takes a long time to review them and then produce them, and then you search there and you find records and it takes a long time to review and produce them. And so it's not the case that you must do the search all at once. The search can occur over the course of the whole request. And so I guess tying it all together here, you have quite a bit of evidence that the people who received this request in Lewis County, that they set about trying to work on it. They set in motion the gathering of records necessary to work on it. That much review was needed of those records at a minimum, because there were many emails, for example, just to use them as an example, that they needed to sort through to find the responsive ones. And it was going to take a long time. And they had many other requests that also were broad and were going to take a long time and review. of those records would take time. And so what they did is they would take a step here, start the process of where the records would come in, and then they would move on and they would work on a different request and get the records and review them and give them out. And this process is exactly what the PRA is designed to be about. And if its purpose is to further the production of records, you should not, by rote, or as a matter of merely of a missed deadline, find a violation. You should, as Andrews describes, use a flexible approach that really thinks about the policy of the PRA and gauges whether what you've seen in terms of how Lewis County tried to work on these requests as a whole was within the scope. If it was reasonable for it to take 9 or 10 months to get this many records, thousands of pages of records, then the fact that Lewis County made a mistake in not telling the plaintiffs that it was still working on it doesn't mean they violated the PRA. Thank you.
Thank you. Mr. Thomas?
Thank you, Your Honor. I'll try to keep this brief. But in addition to the failure to make an extension and failure to communicate an extension with plaintiffs, as I previously argued before the break this morning, plaintiffs also had documents available to them on July 20th. I'll bring this court's attention back to the declaration of Ms. Amron on page 4 in paragraphs 11 and 12. She states that she asked IT employee Matt Trent in order to do a search for her, and then she said that Matt Trent was buried in search requests in paragraph 12. However, at a later time on July 20th, he came back to her with a production of documents, and then if we look in Ms. Maurerman's declaration on page 3, in paragraphs 14, 15, 16, and 17, especially in paragraph 16 on page 3, Ms. Maurerman states, the risk manager and I located the records that Ms. Amron had acquired. Those records were ready for review and production to the request. I reviewed and produced. Those records were available on July 20th, and they weren't produced for 50 days. So it's not just a failure to communicate, but it's also a failure to produce records that they had in their possession. So let me try to clarify the big difference between the way plaintiffs look at this, plaintiffs look at the Hobbs case and the way defendants look at the Hobbs case, because I think we're both talking about the Hobbs case, but we're looking at it differently. Plaintiffs are looking at the Hobbs case and trying to determine, using the Hobbs case to determine whether in a PRA lawsuit, whether there's an action or inaction indicating that the agency will be providing responsive records. Plaintiffs argue that's from the point of view of the requester. The court doesn't clarify whose point of view you're looking from, whether it's a third party, whether it's the plaintiffs, or whether it's the agency. If the court believes that you're looking from the agency's standpoint, then maybe the court decides in favor of Lewis County in this case, because Lewis County can argue that it's been producing records, although it didn't communicate it and they had the records since July 20th. If you look at from a requester standpoint or from an objective standpoint, plaintiffs should win because there wasn't communication. The records were not given that were given to Ms. Amron on July 20th. There were similar requests that already had produced records that they could have looked through in order to give them. And so the totality of the circumstances led plaintiffs to believe that they were not going to receive any more records. There was no communication and their requests were abandoned. And plaintiffs would assert that the final agency action needs to be construed in favor of the plaintiffs because the Public Records Act under RCW 4256.030 states that it shall be liberally construed in order to effectuate the mandate, which is to get records for people and to penalize agencies and hold them accountable for not producing records. And so that final agency action needs to be liberally construed, and we'll rest on our briefing.
Thank you. Well, I can tell and I appreciate the professionalism that I'm seeing between the two of you in court. It seems that at times in the pleadings there was some rhetoric. And I will just let you both know that the court is not interested in the rhetoric and the attempts at perhaps their humor, I'm not sure, but some of the caption headings and some of the ways things are expressed in briefing, those aren't helpful to the court. What's helpful to the court is when, as you both have done in this argument, really getting down to what the legal difference of opinion is. That's helpful, and I found the arguments that you both made to be very helpful. And so what I would say is this: there's been a violation that Lewis County's had in these two, the 1233-50817 and the 1339-52617. I'm not going to be setting what those penalties for that are today. There'll be a separate hearing that needs to be noted, and I'll give both parties the opportunity to address what the proper penalties are. But the court is satisfied that based upon this record, that Lewis County did withhold these records from the petitioners. Now, I will give you both at least an indication of what I'm thinking, which is that a lot of the facts that Mr. Eisenberg has argued, I think really do go to the penalty portion of this. But I don't think it changes the fact that Lewis County failed in its duty to provide the records that were requested in a lawful manner. And it took, quite frankly, in this court's view, the filing of the lawsuit on September 1st to get those records to petitioners. So that would be the court's finding for today. I would trust that the two of you would be able to find a date for the penalty phase of the hearing. And then I'll hear argument and I'll make a decision on that once you both have said it and briefed it. Any questions?
The plaintiffs didn't bring a proposed order today. I anticipate that we'll be able to work with defendants in order to write one, and we'll note a presentation of the order on the calendar.
That's acceptable to the court.
I do have a question about writing that order. So in terms of the nature of the violation, I do have a footnote where I flag this issue, and the question is the violation a failure to respond within a reasonable time, or is the violation a denial of access to records? The reason I ask is, well, twofold. I guess the question I pose would be, if Lewis County had provided an estimated timeline to the plaintiff saying, we won't be providing these records until September 8th, would the court have still considered for this to be a violation? And the reason I ask that question is that there are separate rules about what penalties apply when the violation is a failure to respond within a reasonable time versus when the violation is a denial of access. So I'm just trying to get a sense of what the likely penalty hearing would be about.
I'll hear from you, Mr. Thomas.
If I may, real quick.
Of course.
For this court, Hobbs talks about final agency action. Plaintiffs argued a final agency action. And Hobbs and both Hickel, which is in our brief, talk about a final agency.
Is it Heichel?
Heichel? I'm sorry if I mispronounced it.
I assumed it was, but I know what you mean.
I apologize if I mispronounced it. Both cases talk about final agency action as a denial to the right to inspect and copy. And actually, if it's either Hickel or Heichel, talks about that statutory costs and attorney's fees is appropriate for a final denial through a final agency action.
And that is the, I was simply, that is the basis of the court's ruling, that under these facts, the record, in effect, the agency allowed too long a delay such that it was a denial of access. But as I said, all of the facts that had been presented, and specifically, I know Mr. Thomas had his motion to strike. But I want to say, I think Lewis County, the facts they put forth are relevant for the court to consider. I think the court does need to look at this fuller picture. So that is the basis of the court's ruling, to give you that clarification. Any other questions?
No, Your Honor.
I don't have any others, thank you.
Very
Oh,
well.
wait, we have on the motion to strike.
We actually did sign a proposal.
Right, so I did not prepare an order for the merits, thinking I would need to hear Your Honor's ruling. But we did have an order just on the motion to strike in sanctions.
In sanctions, very well. Then I'll sign that
Thank you.
one. You're welcome.
Thank you. Thank you, Your Honor.
You're welcome. Well, I hope you both have a good weekend.
You too.
Thank you.